afternoon, everyone. Hi, everyone. Thanks for tuning in to SC by SC FinTech Conference 2020. Today's session is the last session of the day, and it is on data portability, transforming the financial services industry. Please note that you can ask questions that you may have using Slido. What you need to do is go to www.slido.com, SLIDO.com on your devices and key in the event code SCxSC 2020. Or you can just click the Slido link on the chat box, select the relevant session and key in your questions there. Okay, so what we're going to do is we're going to take questions along the way while our speakers speak on the subject. Okay, what is data portability? It's quite an alien concept under Malaysian law, under Malaysian data protection law, because we don't have the right to data portability under the Malaysian PDPA. Simply put, and our guests from the UK and Singapore will explain a bit more, it's a process that allows data to be transferred or ported from one service provider to another. And as I mentioned, currently, it is not recognized under Malaysian data protection law. The closest that we have in terms of data portability under our Malaysian law is data access, request for access to information. But that's only for the data subject to request access, but it doesn't allow porting or transferring of information from one service provider to another. However, in this year's earlier this year, the Personal Data Protection Commissioner issued a consultation paper on the amendments to the PDPA, and one of the provisions, proposed provisions that is meant to be incorporated into the new amended data protection law is data portability. So it is an interesting time for us to have two speakers today, Joanne Venkatesan from Pennington's Manchester Cooper in the UK, and Adrian Fisher from Linklater, Singapore. They're both data protection lawyers, and both these jurisdictions have somewhat recognized data, correct me if I'm wrong, but they have somewhat recognized some right to port data. So they are going to be able to explain a bit more on data portability for us to understand it. I'm going to start with Joanne, and to ask a very basic question of what exactly is data portability and why is it required?
Thanks, Adeline, and great to meet you all. So yes, you're correct. We do have a law which recognizes the right of individuals to data portability in the UK, and this stems from the GDPR. So it is a right that applies throughout the European Union. And basically, it is allied to the right of access that you already have under the PDPA. It belongs to the individual, and it is allowing the individual to request certain types of information that they have provided to a service provider, a data controller, to be transferred to another controller in an easy format. So you might think, why do we need such an additional thing if we already have the right of access? And what is the difference? So this is basically to increase competition and make it easier for a consumer to approach another vendor and transfer their data to the other vendor, perhaps to see if they can get a better deal. In the UK, in the financial services sector, it was allied to the Payment Services Directive, which also was increased in transparency and open banking. So specifically in relation to, bank account data. If you think, me as an individual, I might want to know easily what my data looks like, what my spending data looks like across all of the bank accounts that I have. And previously, this might have been a difficult thing to achieve because I would have had to look, either in each of the different accounts, and my data was in different places. So this allows me to easily get the data, and actually might allow me also to directly require one bank to share the data with another. So in brief, that's what data portability is. from a UK perspective.
What about the Singapore perspective, Adrian? Is it different from what Joanne has described just now?
Yes, thanks, Adeline, and great to be here on this panel. Thanks very much for having me. So it is different in that there is no data portability right at the moment. So we're expecting one to be put in place very shortly. In fact, there is an amendment bill to the PDPA in Singapore, which has been released and has been consulted on, and I think in the next few months we'll probably see that passed. So the PDPA is actually undergoing a major facelift at the moment, not just to introduce data portability rights, but also to change some of the processing grounds to introduce data breach notification and a few other things. So it's quite a major overhaul of the law here, but data portability is a big part of that. And so it sounds like perhaps we here in Singapore are maybe a few months or a year ahead of where Malaysia is, if you're just consulting on it now, because we had a consultation probably a year or so ago around it. And during that consultation, actually, the PDPC talked about why a data portability right is important, and it echoes a lot of what Joanne's saying. And in fact, I would say the GDPR is where all of us are drawing inspiration from. It's been, this right has been in the GDPR and EU law, I guess, for much longer than this reason, than this region. So it's coming in Singapore, and I can talk a little bit about some of the elements of the right that is being discussed. But yeah, but the reasons for it being talked about now are very much in line with what Joanna said. Singapore, like Malaysia, like many other parts of the region and the world, are going through a real digitization process, and I think one reason this is will potentially be quite a powerful right is that in Singapore we're having a whole bunch of digital banks that will be licensed in the coming month, probably, or soon, and once those digital banks are up and running, the idea really is that from a financial service perspective, there'll be a lot more competition for opening bank accounts. So if I think about my own banking experience, I opened a bank account when I was 10 with the Commonwealth Bank in Canberra. I still have that account, but now obviously there's a lot more choice open to me. And so if I want to move, say in Singapore, if I bank with DBS, if I want to move to a digital bank next year, data portability will allow me to take my information and move it to my new bank more easily, probably than today. So in short, yeah, it's not in place yet, but will be very soon.
So based on what you're saying, it seems to be more impactful for fintech companies. How would that then impact the traditional banks? Would that be more? Would that mean that there's less? There's more competition for these traditional banks, financial service providers?
Should I go?
Yeah.
Oh, sorry, Adrian.
No, go for it, Joanne.
I think, yes, it is something that has shaken up the banks, because the banks are the custodians of the existing data that belongs to the individual, which will be subject to the data portability right. So the culture of banks is typically, security is utmost, limitation of purpose of use of the data is utmostly important. So having to share your data with a competitor is an unusual thing for the banks to get their head around. And I think one of the first things that the industry had to think about when they were dealing with how to address the right of data portability was the concept that actually the data isn't theirs as such. It belongs to the individual. And here we draw a line, which is an important line for the industry. And I know, Adrian, we were talking about this earlier. It's what kind of data falls within the scope of the data portability right. I do not know the status of the consultations in relation to this point, but the way that it works in the UK and under the GDPR is that the scope of data is quite an important thing. So most financial institutions will enhance data that an individual provides to them in some way. The data portability right affects right that a bank will process in relation to the contract that it has with the individual. So the kind of data that would be your actual transactional data, let's say, your account, the services that you use, the transactions that you make within your account, and any other data that you have given to them, which the bank processes by virtue of your agreement, for example, including in relation to, you know, marketing services that you might have been interested in, that kind of thing. So it's that scope of data that falls within the right of data portability. However, there's also other interesting types of data that a bank would use to associate with an individual, such as, you know, the money laundering checks, the enhancements to do with the consumer profile of a particular bank account. So this kind of enriched data isn't subject to the data portability right, and neither is analytics. So if you have applied some analytics to the existing raw data that you have, and come up with some trends generally which are useful for your bank, which are your trade secrets and commercial information, that is where the line is drawn between that kind of information is also not subject to the data portability right, and you wouldn't have to share that with a consumer. So it's important on both sides of the coin, because from a bank's perspective, we have to gear up to make sure that we totally understand, in terms of an internal data governance perspective, what data is affected by the right of data portability and what data isn't. And we have to find an easy way to comply. And then from a fintech's perspective, you also have to understand what kind of data you could access, and actually how it might enrich the kind of services that you may provide. Now, these could be services that you could provide to a bank. For example, development services, API services are much talked about to provide the interface to allow the portability right, the data to be transferred. Or it could be just some sort of services around the customer experience. You know, how can a customer exercise its right, making it easy for the customer to exercise their right in relation to multiple banks, and just providing a technology and experience around that. So I think it's twofold.
Yeah, and I think, yeah. So from my perspective, I think you asked how will it impact traditional banks, and I guess I mean, I think it will be quite significant in Singapore, and the scope of data is really important, as Joanne mentioned, and I'll come back to that. But I think when faced with this this almost existential crisis around, you know, do we have to hand over our information to competitors? There's probably a choice here, right? Banks can either dig their heels in and make it as hard as possible for that to happen, or you know, they can make a decision that this is kind of the way of the world. And there's been a lot of discussion around open banking and open APIs. I know in Singapore, for example, DBS has done a lot of work around kind of opening up APIs so third parties can kind of integrate a bit more with its ecosystem. So I think it's probably a bit of an existential question around how banks want to react to this, and certainly that there are different ways you can do it. But I do think this question as to what data do we have to hand across if asked is really important, because clearly a bank will hold a lot of information about me. I mean, I just gave you an example of my Australian bank who I've banked with for 20, 30 years, across a number of products, sometimes with joint accounts with my wife as I got married, etc. So there's a huge amount of information, and as Joanne said, banks are also now technology houses, and so they're doing a lot of stuff with that information to benefit me, but also to improve the products that they have. So this point around what data falls within the right has been a large part of the consultation in Singapore, and I presume the Malaysian discussion will be similar, because actually when it was first consulted upon, it was very broad, and it just said this right will apply to user provided information, so my name, my email address, the stuff that I give when I sign up. It will apply to user activity information, which could be transaction history, payments history, when I accessed, the ATM or whatever. And similar, it sounds like, to the EU, they said derived data, so stuff which the bank kind of applies analytics to would not fall within this right. But even then, a lot of the feedback that was received was that this is so broad. Like, what does this actually mean? What do we have to hand over if we're asked for it? And so where the PDPC has landed in the kind of amendment bill, which is now, I think, near final, is having a white list of data. And so what they're actually talking about is doing a kind of an industry, kind of through industry collaboration, reaching out to the different industries to whom this right applies, and actually coming to an agreement as to what data would fall within the right. So I guess, and I should make clear, the data portability right is broader than just financial services, right? So it impacts utilities, energy, etc., telecoms as well. So all of those will have different types of data sets. And so the way they're going to do it in Singapore is to have that kind of consultation. So I presume that means banks and fintechs and the PDPC will come together and talk about what's doable and what's not, because there's obviously a big cost implication to be able to get all this information in a format that is ready to just pass across to someone else. So those are some of the challenges, I think, that traditional banks will have to come up against in the near future here in Singapore.
So you're saying that it's more of they're going to take a very sector-specific approach when it comes to data portability in Singapore?
Yeah, that's the way the consultation has been framed.
Right.
That's right. So they've even spoken about codes of practice for different industries. And I should just add that seems similar to the Australian experience. So Australia introduced a data portability right kind of over the last 12 to 18 months. It's called something different. They call it the consumer data right. And actually that law, or those rights, have come out of the Competition Authority rather than being led by the data privacy authorities. But similarly, the way that Australia is rolling it out is on a sector basis. So they started with financial services. And I think that became live in the last few months, actually. And now they're beginning to consult with the energy and utilities sector. So that seems to be the way it's happened in Australia and now here in Singapore.
Is that the approach in the UK, Joanne?
In the UK, what the data portability right was rolled out generally across the board. So, for example, I helped Jimmy Choo comply with their data portability right, which was one of the more fun data protection projects that we were involved in. But in that context, it's literally about owning your, if you think about Amazon and your wish lists and your purchase history, as a consumer, wanting to make use of that kind of personal information to understand yourself and your spending habits and what you might want better. So it was not rolled out in a sector-specific approach. However, that said, there are sector-specific layers on this. So, for example, financial services is a very specific sector which has been affected by the GDPR and the Open Banking Payment Services Directive concept at the same time. So there was, there's a sector-specific approach there, but no, it wasn't rolled out one by one.
Okay. Well, in that case, Adrian, I think in Malaysia it'll be a bit simpler because we already have sector-specific laws on data protection. We have the main PDPA, then we have the codes of practice for different industries, including financial services and telecommunications, utilities, etc. So I suppose when we roll out data portability, we can make use of the sector-specific codes that we have and incorporate the data portability provisions in there. So it will probably make it simpler for Malaysia. Right?
Yeah, and it means you probably got the infrastructure set up for dialogue, because I think that's part of the reason the PDPC is going down this path. They want to make sure that they've included sufficient industry kind of feedback and discussion, which in a place like Singapore and maybe Malaysia is maybe more manageable than the UK or the EU. I'm not sure, but Singapore definitely, I think the culture of the privacy regulator here is very much about collaboration and getting feedback and making sure that it kind of finds its way into the regulation as well.
That's what's happening in Malaysia, because even the codes of practice, it's being drafted. It's been drafted by the industry instead of the PDP commissioner. Okay, so I have one question on a general question on PDPA laws in Malaysia. The question is, do you agree that PDPA laws in Malaysia is more narrow compared to other foreign international privacy laws? So I suppose I have to address it very briefly from the Malaysian perspective. And I think that our PDP laws have not met the gold standards that have been set by the GDPR, EU GDPR. So, and there are some provisions that are now being amended to be in line with the GDPR, including data portability. We also have a blanket exemption when it comes to our government, because it states that the law states that it doesn't apply to the government, federal or the state government. And there are also provisions such as data breach notification that would be in many laws right now, but they are not in our data protection law. So from that perspective, yes, it is still narrow or may not be adequate compared to laws in other jurisdictions. What do you think? How, if you compare it with the laws in your jurisdiction? Joanne, maybe you can start first.
Sure. Yes, I think from what I can see, and I did briefly look at the PDPA, with you, Adeline, a while ago, and I could see that there's a lot of concepts that are very similar to the GDPR, the kind of rights, the kind of thought process about data governance and how you treat it. But yes, I think that it is a narrow approach because blanket exemptions for the government would be tricky to deal with from what we have in the EU is the concept that data flows may be transferred to other countries which have laws that are regarded as adequate from a data protection perspective from the EU Commission. So, for example, Japan recently has received an adequacy decision, meaning that data can be transferred from the EU to Japan and Japan to the EU without any kind of issues, because the EU regards the data as being sufficiently secure when it goes to Japan. Contrast this with the US position, where there are kind of, you might have seen in the press, I don't know, but there was previously this safe harbor type arrangement called the Privacy Shield, under which the EU and the US allowed data to be transferred to certain countries in the US who were Privacy Shield certified, meaning that they agreed to comply with EU principles in relation to data that was received from the EU. So this was allowing data to be transferred between the EU and the US. However, the European Court of Justice recently held that the Privacy Shield was invalid. And the reason for that is interesting if you think about the context of Malaysia. The reason was overly broad access to that data by the US government, which was regarded as going to be going to erode the sort of protections that should be expected for EU data subjects. So I think that if you were thinking about the Malaysian data protection regime, from that perspective, I think the blanket exemption could cause concern, I would say, probably.
Adrian, any views on this?
Yeah, I mean, I think we've spent a lot of time together working on kind of Malaysian and Singapore questions, and I think there's a lot of similarity between the Singapore PDPA and the Malaysia PDPA. I think there are some differences, right? I know in the Malaysian PDPA, I recall that you have to register, perhaps if you're a data user or a certain type of data user, where in Singapore there are no registration requirements. The point around government application to government is also a similarity, and I certainly, I can understand, coming from an EU perspective, it sounds strange that your privacy law doesn't apply to government, but in Singapore it's it's the same. So it only applies to private organisations. I think there's some query as to whether that will change at some point in the future, because actually the largest data breach that we've had here in Singapore was the Singh health breach, which you may have heard of. I mean, there was a hack of kind of the national health records, and I think 1.5 million people, 1.5 million people's records were somehow taken, or in some form. So it was very substantial, and I think it did raise some questions which were discussed at the time around the application of privacy principles to government. I can definitely see similarities between Malaysia and Singapore. I mean, one thing I would say about the Singapore law, which may be the same in Malaysia, I'm not sure, is but definitely something that distinguishes us from Europe, is that it's quite a business-friendly law, I would say. I mean, we certainly have rights for individuals. So we have access rights. We have, the data portability right, hopefully soon. There are rights to kind of correct your information, to withdraw your consent, or a lot of the stuff that feels familiar from the GDPR. But I do think that the GDPR puts more of a focus on the individual, whereas the law in Singapore, a lot of it is around how can organizations, make sure that we're doing the best for individuals while still managing to run our businesses. So there probably is a bit more of a business focus. I think in this whole discussion, when you're comparing laws, one really important point is around enforcement, though. And I'm not quite sure where things are at in Malaysia, but one thing we do have in Singapore is a very active regulator. So we have 30 or 40 or 50 enforcement cases a year, and they really they release all the decisions. They're very public around how they're enforcing. So those are a few comments. Yeah.
Interesting to note. Does Singapore also have similar exemptions for government agencies or government ministries?
Yes.
Oh,
yeah.
Okay. It's not blanket though, right? I mean, because ours is just all up, just very expressly states that it does not apply to the government.
Yeah. No, it's the same. Yeah, it's the same.
Okay.
It's the same. But in this most recent the changes that I was talking about to the Singapore law, they are going to bring in, I think, private organisations that act on behalf of government. So if there are companies who have some kind of government mandate, that I think they will now fall within the PDPA. But government agencies remain kind of excluded. Yeah.
But okay, just to clarify that a bit more, I was under the impression that for Singapore, there's a list of government agencies for which the PDPA is exempted, as opposed to Malaysia, where it's completely blanket.
No, it's
okay.
blanket as well.
All right, I see.
Yeah.
An interesting
Yeah.
revelation. Similar in that sense.
Yeah.
Okay. Another question that we have is on customer data rights. I think the issue is whether with data portability, a customer can prevent the capitalizing of data by fintech providers or by financial service providers. I think the simple answer to that is probably consent. But if you could elaborate a bit more on how that is done. Perhaps you want to start, Joanne?
Sure, yeah. I think transparency is key. Transparency is very important because it sets out the expectation for what is going to be done with consumer data. And if we're talking about, what can be done with the data to commercialize it and capitalize on it, I think there are a couple of things that organizations would normally do. One is to use that data for marketing purposes, to try and generate further work from further services and sales from the individual concerned. Whether that is certainly, in the UK, this is the sort of thing of the past, but services directly for that organization and services for others. So the marketing element of it. And then the second element of it is the knowledge and the information that you can acquire from consumer behaviors, customer behaviors, which can enrich the way that you operate. So the analytics side of things. And I think for us, the way it works is that, similar to you have to provide a data user or data controller would have to provide a privacy notice to individuals. So one of the things, if the data portability right becomes law in Malaysia, I would imagine, is that you would be updating your privacy notices to include reference to the new right. And you would be identifying to individuals that they have this right. part of what we typically do here in privacy notices is we also are very transparent about the fact that data could be used for analytics purposes. So that is made aware to individuals, and that, you know, so that information you could still keep, and you would not be prevented from using. Excuse me, dog. It's the postman, you know, anytime he gets very vocal around this time. So I'll just wrap up by saying the marketing side of things, I don't think would be overly impacted by the specific portability right, but it is getting more difficult in the UK and the EU because of the granular nature of marketing consent. That doesn't apply immediately to business contacts at the moment, but it is an area where there is just an increasing focus on what you can and can't do in terms of marketing. So yeah.
And in Singapore, the consultation papers to date have made clear that the PDPC views data portability as one thing, and then processing grounds as another. So I guess if I was, wanting to move from a traditional bank to a fintech for deposit taking services or something, I guess my right is to say to my existing bank, can you please pass all of my information and my transaction history required to provide me with that, that bank account to the fintech. But that doesn't actually then mean the fintech can do whatever it wants with the information that is ported across. They still need to make sure they've complied with the PDPA for whatever purposes that they want to use my information for. So going to Joanne's point, in Singapore you would also have a privacy notice and there'd be consent, and so the fintech would need to make sure that whatever it intends to use the information for, people it's going to disclose to, etc., that is transparent with me in that process. So there's no, I guess, imputed purpose when you're exercising your data portability right. I mean, perhaps one other just interesting thing to note in Singapore through this overhaul of the PDPA that's undergoing right now is that the PDPC is looking to put in place some, I think, fairly novel processing grounds. Certainly there's this one called the business improvement exception, I think is how they refer to it, which I haven't seen elsewhere. And effectively what it allows, it allows companies to use personal information that they collect for analytics internally. So as long as it's within the company's kind of four walls to improve products or, get a better sense of their customers without actually getting consent. I think there are some notification requirements, so you might need to make sure your privacy notices are up to date. But it's quite an interesting, I guess, move away from Singapore. Singapore law is very traditionally consent based, so you got to get consent for everything. But now they're kind of moving away from that. So that may be an interesting feature. I don't know if that will also rub off on the Malaysian PDPA at some stage, but that's coming into force soon here.
Connected to that question is another interesting question in terms of accountability. When it comes to data portability, the question is who's going to be accountable for the data? Are the laws in your jurisdiction, I mean, in the EU, for example, is it very clear on that? And is a Singapore consultation paper, does it address that?
Yeah, I might just jump in first because I was kind of refreshing my memory of the consultation papers before this, and this point did come up because actually I think initially in the initial consultations the PDP was suggesting that the receiving entity would have to verify that the accuracy of all the information when it's received, and through feedback just kind of got rid of that. But there is a question as to, I guess, the technical kind of interoperability between the porting organization, the bank, and the receiving information, the fintech. And the PDPC has kicked that can down the road. There's no answer right now. So right now what they're saying is that there will be technical standards that will have to be set out somehow and somewhere, but that kind of like the whitelist that I was talking about, that will be done later. So they'll have some regulations or some codes of practice or something which sets out, I guess, the interoperability standards, which I think goes in some ways to making sure that there's a clean pipe so that everyone knows how information is being transferred. So I think a lot of it remains to be seen actually in Singapore, but it's a very good question. What happens if something goes wrong in transit? Who is actually responsible?
Yeah. Just to add to that, in the GDPR data portability, so there's a couple of elements when you think about the transfer of the data and who is responsible. One is, the responsibility for the data when it leaves your system, and then the responsibility for the data when it arrives with the new data controller or data user. So in terms of the responsibility for legal compliance with the data by the recipient, because you think about it, okay, I'm an individual and I'm going to say to Bank A, please can you transfer my data to Bank B? So Bank A has got to make that transfer. So mercifully, the laws do provide that Bank B is wholly responsible for complying with the data that it receives. And so Bank A's responsibility ceases in terms of ensuring that the data is transferred in a safe manner. So the recipient still has to make sure that they have a lawful basis for using that data, which, by the way, we don't have a business improvement type concept, but I agree that the concept of consent is proving quite narrow, and the use of consent is narrowing in the EU environment to only circumstances where genuinely consent is demanded. So we don't have the business improvement type of concept, but a concept that might be useful for the Malaysian environment, the legitimate interests type of thing. That is how we would, as a business, process data for a legitimate reason, legitimate business reason, so long as it isn't overly trespassing on the rights or freedoms of individuals. So that's how it would work. And then just in relation to the interoperability, the way that the law is implemented states that you have to satisfy the data portability requirement without hindrance, one, and where technically feasible, where two. So the without hindrance concept is more about just, not making things too difficult for an individual to actually achieve the transfer of their data from you to someone else. There might be business reasons why, the business says, oh, it's not really in our interests to do this and to allow it to happen really quickly. Well, that is why, and that's there's a specific requirement in our laws that data portability rights have to be complied with without hindrance. Don't make it too difficult for somebody to do what they need to do. But the second element is also useful because you only have to do it where it's technically feasible, meaning that you don't have to revamp your entire systems just so that you can comply with this right. But you have to act in a reasonable manner. So you have to actively look for how you can technically comply, and so whether it is exporting data into an encrypted Excel spreadsheet, that should be technically feasible for most organizations. So there are some formats that are, getting increasingly used because they are formats which you could upload data into and allow it to be accessed. Or a lot of businesses comply with the data portability right through use of their own portals. So you might have a My Data section or a My Account section, and you want information. Well, you can just ask for it and it'll be uploaded there. And then the individual can do what they want in terms of taking that data within your, security parameters. So yeah.
Okay. From your experience, Joanne, have you seen how disruptive is data portability? This is one question that I think that would be of interest in terms of the implementation, the actual implementation of this right.
Yeah, I think it is extremely disruptive. I think we aren't really seeing the full force and impact of everything because these things take time. For example, I'm working with a challenger bank. And what they do is, they make use of this right in quite an interesting way. They partner with various banks. So they partner with various banks. You sign up with them. They will help you, I think, acquire your data because you will get the permissions, and then they will provide you with the best deal from their partner banks, pretty much. So it's an easy way for you to use your data to get that choice. I think we've seen it being used. We've seen a lot of disruption happening in insurance.
Yeah.
And you probably have the same, I think, with the growth of comparison sites, and I think utilities and insurance, I'd say, have had a lot more impact, and with things moving a little bit more slowly with the banking side of things, but I think it's definitely having a lot of impact because the banks are having to deal with the digitization, like you were talking about, Adrian, and the fact that there is a consumer expectation that their data will be capable of being accessed and used in a way which they want. And also, I don't know if you have this overarching concept in your laws in Singapore and Malaysia of privacy by design. Not yet?
Not in Malaysia yet, though. I'm not sure.
No, it's not legislated, but we do talk about it. Yeah, but it's not legislated. Yeah.
So I think, with privacy by design, in order to comply with, even if you don't have a specific, you could say, oh, well, because we have a mandated concept of thinking about privacy by design in your practices. So if you link that together with the data protection, data portability right, where there's a qualification of, where it's technically feasible, but really when you are planning going forward, you've got to be thinking about, how do I implement privacy by design? And going forward, that might mean that you need to actively think about how you might address rights which previously were not technically feasible as part of your overall structure of what you offer to consumers.
Yeah, and it's much easier for a fintech or a new digital bank to hardwire that because they're building their systems now, and they're probably quite agile systems, and they're probably already used to kind of tagging data and where it sits and who, But a legacy bank, I mean, it must. Yeah, I don't know how some of these larger, older institutions have been starting to comply with these rights, because it's hard. Firstly, they need to find out where their data actually sits, which is not always an easy question to answer.
So in that sense, do you think there'll be challenges in terms of its implementation? Because, what is transfer without hindrance, and what is what exactly is interoperability is an issue that can be, because the law is wide, and it can be interpreted in a very wide way or a very narrow way depending on what you want out of it. So do you foresee challenges, Adrian, in Singapore? And Joanne, is there currently any challenge when it comes to implementation?
So I think in Singapore, yes, absolutely. And I think we're seeing those challenges come out through the consultations, because as I said, it started as, oh yeah, we're going to have this thing called a data portability right. It means if you're asked, you've got to transfer the data you hold about an individual to another company. It's like, okay, that sounds great. Then, feedback pours in from every corner of every industry. The second consultation starts talking about, okay, well, we realize we now need to scope the data better. So we're going to start talking about whitelisting. I mean, that process still has to happen, right? I mean, so that has actually been done yet. We're going to have to think about the technical standards for interoperability, and then also just things like fees. I mean, there's a provision in the amendment bill and the consultation around a bank in this example, say that the controller being able to charge a reasonable fee for data portability. I mean, if a bank has had to spend $10 million to set up a whole system to be able to actually track and tag information to comply with this law, does that mean it can then just divide that $10 million by the number of data requests it gets in the first 2 years? I mean, I don't know. So there's also a question of, the commercial question around how it's actually going to be implemented, and then even things like timing. I was reading again in the consultation paper as I was refreshing my mind about it, and there is a statement that you should comply with the request within 7 days. I mean, going back to my example, if I've had a bank account, with a bank for 30 years, yeah, I mean, you're assuming that in 7 days they can actually identify all the information that needs to be sent. So I really think the devil's in the detail. I mean, I think it's a great right. I think it can have profound impact, but I do think difficult to implement. So I guess we're just starting that journey here in Singapore. Yeah.
Joanne, any views?
Well, I see that even though the data portability right was brought into law 2 years ago here, when we talk about what fintechs are doing with the data, a lot of it seems to be development and testing. How do you engage with the banks? How you, developing an interface to allow the bank to allow consumers to, see that data. And so the right is there. The right is there to see your information. It certainly has become a lot easier to get copies of your bank statements, for example, which used to be a bit of a hassle. So, historical copies of your own information, that is a positive step. However, I think it's just still in the process. I think we've only, it's just the tip of the iceberg, really, for from what I can see of how this right is going to shake things up, even here, even 2 years on.
Another interesting question that we have is whether data portability does in fact allow greater data exchange. Does it in fact achieve that purpose?
Can I?
Yeah, go for it. That's a really interesting question. So I'll go after you.
I think it doesn't allow greater data exchange because I don't think it's giving you more information than you would have been entitled to under your access rights. I don't think so. It's just that if you are complying with access rights, you kind of can information dump to an individual, and you can provide it in a way which is quite cluttered, really, even though you're supposed to explain what it's for and stuff. So it's less easy for an individual to make use of it. Whereas here, even though the breadth of the information isn't different, I think the way that it needs to be provided in a structured format makes it more useful. That's my perspective.
Yeah, I agree with all that. And I think, Joanne, it's a great comment that actually there are already access rights. So I think you're right to a certain extent. I mean, companies should already have the processes in place to make this information available. It's just now changing how it's made available and to whom it goes to. But I think in terms of whether this helps data exchange, I guess it kind of does, but I think we always need to remember that data portability rights are the right of the individual. So it only allows, it's really there to allow me to more freely change my energy provider, my electricity provider, or change bank accounts. So it is limited in that sense. It's all about me having the power to have that choice and make that choice more easily, not to enable the wonderful new digital banks to be able to get a whole bunch more information about me than they would otherwise be able to. So I think that's an important point. I guess the other important point probably goes back to the comments Joanne was making to the previous question, is that it's only as useful as if it's exercised. And I could see a scenario in Singapore. Singaporeans, and I'm like this as well, and probably most people are like this, we don't really like change, right? I've already told you I had the same bank account for 30 years. I'm not necessarily just going to jump and change to a digital bank who suddenly advertises, a wonderful new product. And similarly with utilities here, I mean, in Singapore, we've only had competition in electricity for the last 9 months. And so just because we have this right doesn't mean that actually everyone's going to be jumping around and changing. It's really just there to facilitate. So I think it is useful, but yeah, we've got to remember what the purpose of it is.
That's a very good point, actually. Yeah, it is the right of the individual. So, it is, I think from a business perspective, from a fintech perspective, you think, data portability, that means I can get access to a whole load of information to help me do my thinking about the product and how I want it to fit into the, and to the offering on the market. Yes, you can have access to the information only if you are engaged together with the individual. So you have to, I think where it would be really useful is if a fintech offering thinks about the data that it wants, thinks about what it could develop to be really useful to the market and how it can engage with the consumer to help the consumer understand what they can do to help the fintech get the data and make it useful. And ideally, even better, if you can do so in a test method with a bank, so that a bank is actually, showing you, well, actually, this is the sort of data, dummy data that I could make available. Then you think, well, this is the kind of data that I could have access to if a consumer was to buy into my concept. And then I can make something really useful, which is going to be interesting to my consumer, that the banks are ready to deal with, that is going to make me a good partner across the board. So yeah.
And actually, just on that, one discussion point in the consultation papers for the PDPA amendments to introduce data portability rights is around whether it's a push or a pull. So effectively, whether me as an individual has to ask DBS, please shift my information to X digital bank, and then DBS pushes that information, or in fact whether when I'm being kind of courted by the new digital bank, they will say, listen, give me consent to pull this information from DBS, and then actually then the new digital bank can kind of control that process a lot more. And so there's actually, again, the PDPC is kicking this down the road, and they're saying, listen, in the regulations, in the code of practice, we want to talk a bit more about the situations in which actually the receiving party can control that process, which I think goes to what you're saying, because then it empowers that organization to be much more creative and kind of sell things to their customers, convince them as to what data sets they need and why. So I think that is an important part of the discussion.
Both your answers just now is connected to the next question, which is rather controversial, but it's a very interesting question. And hang on, let me read it. It says, this is going to be the last question because we have only about less than 10 minutes. Question is data portability actually protecting the rights of the individual or giving more rights to the individual? Or is it really a means for the company to obtain more data, which they don't normally own?
It comes back to the fact that it is the right that belongs to the individual. So, and also the way that people engage with, the way that businesses engage with the individual, or this is, okay, I have to start off again by saying that the perspective that I'm speaking from is the very EU-centric perspective of that data protection law is all about the individual. That's the culture. It's all about the right of the individual. So I think it is aimed at making life easier for the individual. And what a business could offer to make, to help you make use of your data, it could be something that you have not thought about before, but it will only engage if you want it to. So I think it's still, I think it's just, it's enhancing what an individual could do, but there is a role for fintechs in helping the individual to understand what they could do.
Yeah, I generally agree. I think there's probably layers to the question. I mean, one is obviously for me to just open a bank account and just to port over some basic information about me to get that bank account opened, that's obviously for my benefit. Probably not that helpful really, because it probably would just it'd be as easy for me just to provide the information directly to the new organization. But I think that's certainly somewhere where I can see it's just a new right for the individual to make the process easier. I guess where the second layer that I was thinking about, where it may get more expansive and I guess individuals could be taken for a ride a little bit, if I can put it like that, is the example I was talking about, where information is pulled. So maybe a wonderful fintech comes up with some idea and needs all this certain data sets to be able to implement the idea, and then convinces me to to kind of pull that information from DBS, but maybe I'm not really, haven't focused on why they want that information, what they're going to use it for. I mean, this is a complete hypothetical, but I guess that could be possible. So this is we're playing with a new law, at least in Singapore. We're playing with a new types of business and technologies, and so there's a lot of unknown, right? And so you could see that people could get quite creative with it. And I think ultimately then it's about two things. I mean, one is the industry being responsible and being open, but also about regulatory oversight. And you'd hope that, say in Singapore, the PDPC is kind of keeping an eye on how this law is actually being used.
I think that would apply in Malaysia as well. At the end of the day, it is the regulatory oversight that we're looking at. But I think the advantage, as I mentioned, that we have in Malaysia is that we already have sector-specific regulations or codes that would regulate that. So it'll probably make it a bit easier to implement data portability requirements under our law. Because from what I've seen from the laws on data portability, it's not just the law itself, but there are other guidelines that set out provisions in relation to the technical elements involved, and that is, I think, would be the trickiest part when it comes to implementation. Okay, we need to wrap up now. Are there any last words that you have, both Joanne and Adrian? For Malaysia, that we don't have anything yet, so perhaps any words of advice in terms of the implementation or what we need to look out for?
I would just say with greater power comes greater responsibility. So, I mean, I think the key with privacy is always about having a balance, common sense. Making sure you are thinking about the greater good and being transparent with your consumers. But it's an exciting time, and I think fintech in Southeast Asia it's just such a great industry. And so I wish all the people on this call, on the line, a lot of success.
Thanks, Adrian. Joanne?
Yes, mine is allied to that actually, but the responsibility. And I think one area of which I think will see great growth is technology that assists in regulatory compliance, RegTech, a subset of fintech. And so if you're thinking about the data that is moving around, how consumers are going to be making use of the data, how banks are going to want to make use of the data, what is this data, how do you identify it? And actually we are all, they're operating in a highly regulated environment. So understanding the regulations and designing something which is in keeping with the regulations and has the ability to move with the times as the regulations move, I think that will be, that is where there's going to be a lot of, capability for success with the fintechs, because it's going to make the banks want to engage as well. So yeah, good luck for me, and thank you for inviting me again.
Thank you. Thanks, Adrian and Joanne. That's a wrap today, everyone, for SC by SC 2020. Be sure to tune in at 9:30 a.m. tomorrow for the first session of day 2, which is investment behavior in turbulent times. Remember that you can utilize the networking features on the Brella platform to interact with other participants. Thanks, and enjoy the rest of SC by SC 2020. Thanks again to the speakers. Bye.
Thank you. Bye-bye.